Good afternoon, everyone. Thank you for attending today's webinar, ACI, Receiving AMPS Penalties and How to Avoid Them. We're also going to go through some updates since ACI became mandatory. We're going to cover information that we've learned from CBSA and scenarios that we've come across as far as AMPS penalties are concerned regarding ACI. My name is Justin Knowlton, moderator for today's webinar. Today's webinar will be hosted by Debbie Dent. Debbie is BorderConnect's Director of Consulting Services and has 35 years of experience in the customs and logistics fields. She will be providing an explanation of updates to CBSA's AMPS penalty system in regards to ACI and what it means to you as a carrier crossing into Canada. This webinar will answer many of the questions that we are being asked and will provide valuable information. For anyone who has questions, you can simply use the chat box and type in your question during the course of the webinar, and we will answer your questions at the conclusion. So, without further ado, here is Debbie Dent.
Good afternoon. Thanks for joining us today. As many of you know, this particular webinar is going to include information that was learned from a meeting that I attended last week, specifically with the officials from Ottawa that are managing more so the penalties that carriers have received. Some of you in attending today have received a penalty. I know are very concerned about the amount of that penalty, and we're going to go through some of the steps that Customs have decided to proceed with at this time. I'd like to say right up front that this is probably one of the most heated topics in a long time at a meeting that I've attended, and there was definitely a lot of concern by the carrier community that had attended that specific meeting, and there definitely was some I'll say tongue-in-cheek with Canada Customs that they readily admit there was and is some room for improvement here, but what's going to be able to be done is still yet to be known. Let's just go through a little bit of ACI background. Advanced Commercial Information is a new way of doing business with Canada Border Service Agency, and it is mandatory. It is not one of the voluntary programs like CSA or CTPAD or any of those programs that you can voluntarily decide to participate in. Every carrier crossing the border in a commercial vehicle is subject to that mandatory requirement. So from May 6th to July 10th, highway carriers were provided basically a 45-day transition period from when Customs announced that as of July 10th of 2015, it was going to be mandatory. And it was something that had been on the plate with Canada Customs back from 2012, and they readily admit it took them a long time to roll this out, but on July 10th, 2015, it became mandatory. On July 10th, non-compliant carriers were provided an additional 6-month period to become compliant, and they received zero-rated penalties issued in some cases, but minimally drivers received a warning document on arrival. This 6-month soft enforcement period would end and did end on January 11, 2016. From that date moving forward, carriers arriving at the border were delayed, and in some cases, not 100% of the cases, did receive a monetary penalty. As well, a non-compliant carrier was not allowed to proceed if that e-manifest was not in fact on file. Now let's go through a little bit of background about AMPS, and for some of you it might be the first time that you are aware of this program. The acronym AMPS is the Administrative Monetary Penalty System, and it basically secures compliance for customs regulations through the application of a monetary penalty or a fine or a ticket, just like a police officer issuing a ticket against a speeding offense. AMPS authorizes the Canada Border Service Agency to assess a monetary penalty for noncompliance with customs legislative through regulatory or program requirements. In the case of ACI, AMPS, there were a number of new introduced penalties that were specific to the ACI program, and the partners that would be included in that ACI requirement. So this is the reason that, one, it took so long for Customs to be able to roll out the program, because at the time they had to wait for legislation to be passed to allow them to assess these penalties. And that was in place around May of last year, and as of January 11th, Customs was and are in a position to issue that penalty action. Pre-arrival requirements is a Customs regulation. It is a program, and it is part of the Customs Act, and it's based on Section 12.1 of the Customs Act. ACI mandatory requirement indicated that all commercial carriers, whether empty or loaded, are required to report electronically at least 1 hour before the shipment or the conveyance arrives at the border, unless an exception. For those of you that are carrying CSA shipments, you have the option of not sending an e-manifest in advance of your arrival and going through the standard paper way that you did before. ACI still is mandated for those conveyances that are arriving empty or loaded. They are currently allowing an exception for the empty truck to move forward without an e-manifest on file and without penalty action, but the regulation does still state empty or loaded, it's subject to a report. So reporting 1 hour prior to the arrival means having both conveyance. So conveyance in Canada Customs world is that truck, the trailer, equivalent to on the U.S. side the trip information, and the cargo data is, if there is cargo on that truck, the information about the cargo. Both must be on file with Customs prior to that physical truck's arrival. In some instances, we have seen penalties that were issued when only the trip data or the conveyance data was submitted and not the complete manifest being on file, because in fact when the arrival occurred there was a shipment on board. Carriers are encouraged to submit if empty, but currently, as I mentioned, carriers who are empty, and that's no goods on that truck, are being allowed to proceed, and this will continue and without penalty action. There's no announcement when that will end. Carriers who are traveling in transit through Canada are also allowed an interim exemption, and this will remain in place today. Again, would not be subject to penalty. Every other commercial carrier for hire must have their own carrier code in order to submit the data. Every driver arriving in a commercial truck needs to be prepared to meet the ACI requirements and must have an ACI cover sheet or an equivalent document to support the ACI, meeting that barcoded requirement that you all know is part of the ACI reporting. So Customs can scan a barcode, pull information that's already been pre-risked or pre-reviewed prior to the truck's arrival. Here's an example just of the ACI cover sheet. So the preferred option is obviously for the conveyance reference number, or what we refer to going into the U.S. as the trip number, being in barcoded format. So when the officer scans that barcode, all of the information that's already been electronically communicated comes forward, and in a perfect scenario, that truck would be released because everything is on file and it occurred at least 1 hour prior to the truck's physical arrival. An alternative is to provide Customs with the conveyance reference number just handwritten, but the cargo control number being in a barcoded fashion, whether that be the PARS barcode label on the invoice, but it's submitted to customs in that fashion. The second that's not in place, that is a referral to secondary. That is the start of potential problem and potentially being issued a penalty if in fact they find it's not on file, or when they scan that barcode, nothing comes forward. That's the start of potential problem and a delay at the border. The Administrative Monetary Penalty System, there is a master penalty document that can be found on Customs website. The penalty system in Canada has always been much different than in the U.S. There are a list of contravention numbers with an associated description and with a specific amount that's to be issued against that penalty for a level 1, 2, 3, or subsequent. In the U.S., penalty action is usually much higher, but there isn't this sort of very specific descriptive penalty. And in certain cases, if you were to make a non-report going into the U.S., minimally the penalty could be $5,000, but often they just will issue it against the value of the merchandise. If the value of that merchandise is $200,000, for example, then you may get a $200,000 penalty in the mail. Scary as that might be, the reality is in the U.S. there is a mitigation process that we've all come to expect in doing business with U.S. Customs that is not in place in Canada. So each new penalty is intended to apply to all submission requirements and all trade chain partners responsible for pre-arrival, including the provision that multiple penalties may be issued per shipment if multiple trade chain partners are in contravention of their respective requirements. Penalty is based on the following in the ACI world: failing to provide advance information, failing to provide advance information in the prescribed time frame or in the prescribed manner, failing to correct advance information that's known to be incorrect prior to arrival, failing to provide true, accurate, and complete information, and failing to comply with a customs request for more information when they have received it. If they send you back a message with additional information required, they consider that a risk assessment, and if you don't comply to that or hadn't responded, then of course there could be penalty action for arriving without that being in place. Right now, and to shorten this webinar into the time frame that we have here, currently there are about 900 carriers that have received at least a single penalty to do with ACI since January 11th. I personally right now have on my desk probably about 75 of those 900, and I probably receive on average a daily call or a referral of a penalty that somebody has received where they're looking for some advice. Most of the penalties, if not all of the penalties that have been issued, are penalty 378, where if you read the description to 378, and that will be contained in the penalty notice that you've all received if you've received one, it was determined that the receiver of the penalty failed to submit pre-arrival or pre-load data. And that first level penalty is at $2,000. It is considered a high risk to Canada Customs, according to their definition, based on the fact that they had no opportunity to review or risk in advance of that physical arrival. We know there's a variety of reasons why the information was not on file with Canada Border Service Agency before arrival. In most cases, it was simply human error, either on behalf of someone within the office that might be responsible for creating that electronic send, the party that might be preparing that electronic send, or the driver, quite honestly, who does not communicate with the dispatch and proceeds to the border thinking that everything is all set up. There is definitely a difference between a PARS and the broker having your PARS on file and the ACI being on file matched to that PARS. After we get past the human error element, yes, there may be reasons why a penalty is issued. The unfortunate part is those first level penalties, as long as there's error on your part, it's subject to an issue by Canada Customs, and it's subject to a collection by Canada Customs. The only good news that came out of the meeting that I attended on last Wednesday was that Customs have agreed at this point not to elevate and not to issue any penalty to a carrier at a second or a third level. The second level, if you do not remain compliant within a 12-month period, the second level is $4,000. So now your first level penalty is owed to the government at $2,000, a second level at $4,000, a third level or any subsequent penalties, $8,000. That means you as a carrier, the rule states, you must stay compliant for a 12-month period. Otherwise, you would move up to that second or third level. They have agreed not to issue any, and I do have, unfortunately, a couple carriers that have received a second notice of penalty. I have in one case a carrier who has received a third level of a penalty. In each case, it's still issued at the $2,000. Still very concerning, still coming out of your bottom line of profitability, and I understand that, but it is good news that Customs has at least agreed indefinitely to delay the issue of $4,000 or $8,000 penalties. All penalties are being reviewed and centrally issued right now. For those of you that had the benefit of receiving during the soft enforcement period possibly a report card or an outreach by an officer personally to explain that you weren't in compliance, and unfortunately the only parties that probably got that benefit were larger volume carriers, because we did see a number of these. But that outreach, that centralized location is for the sort of regional Ontario is in Hamilton. At the end of June, Customs was proposing to provide authorization to all of the ports, so an officer at the port would now be in his legal right to issue the penalty for noncompliance, not immediately on arrival to your driver, but he would be, or that person would be the one that was actually generating that penalty. They've decided to again hold back, not to do that, to remain in a more centralized location, have that subject to review so that they feel they're assisting the carrier in, we'll get to that mitigation process. So at this time, it's going to be delayed that an officer at the port, they can refer the shipment for penalty action, but it's referred to that centralized group who supposedly has now been specializing in the issue of these penalties and are reviewing and supposed to be taking other things into consideration before they issue them. We have, unfortunately, clearly seen inconsistencies in the handling from one port to another, whether a port would hold a driver versus a port that doesn't hold up the driver. The border service officer talking to your driver indicates that penalty is going to be issued, where another one says there will be no penalty issued in this instance, but don't do it again. And unfortunately, that penalty then follows and comes in the mail afterwards. They do recognize that they have some internal communication, some misunderstanding, and some training that is still needed before they would roll it out to the port level in order for them to be responsible for issuing the penalty. Penalty mitigation. In the U.S., Mitigation means that you request consideration to the penalty. They will reduce the severity, probably the pain, and they will be less severe. Canada Customs does not have the ability to truly mitigate a penalty in the way that we as the industry think they should. It is not according to the definition of mitigation in the Webster Dictionary, which is the act of mitigating or lessening the force or intensity, the act of making the condition or subsequence less severe, becoming milder, gentler, or less severe. They don't have the right to do any of that. So when Customs put up on their screen in their presentation, which was about the third screen that was presented, I have to say, literally everyone in the room that was looking at this stat went, what? Because Customs basically said that 96% of all issued penalties had received some sort of mitigation in some capacity. I immediately put my hand up and said, please explain the term mitigation then, because that's not what we had seen. So when questioned, there had been no reduction to the amount owing because the current legislation, as I might have already mentioned, does not allow them to lower the amount. But what they did provide us with is evidence that, for example, a carrier that was issued that $2,000 penalty, they had reviewed their history, and if they found other examples of noncompliance, they only issued a $2,000 penalty. We still believe that to be unfair to the smaller carrier. It might work in the benefit of the high volume carrier or the carrier who repetitively is making errors, but that one instance where you've made a mistake and been issued a $2,000 penalty, it definitely appears to be punitive and definitely not corrective, as Customs has always kind of introduced the AMPS program to be. As well, they believe that 88% of the carriers that have been issued an AMPS penalty did receive previous outreach, did receive one of those report cards, did receive zero-rated penalties, did receive a number of actions that they took since 2013, which included compliance action plans, report cards, conducting webinars, hosting conference calls, mass emails, participation in trade events, active discussion with us as the trade partner, Customs web updates, Customs notices, and all ongoing regional support. So basically, their definition of mitigation is that we have all received some sort of mitigation based on the fact that they told us it was coming. Again, you may be a seasonal type carrier. You may not have imported or carried a shipment into Canada within that soft enforcement period. Any of those benefits that maybe other carriers did receive, it's definitely not a level playing field. Your options after receiving the AMPS penalty is to remit payment in Canadian or US dollars payable to the Receiver General for Canada. All clients have an obligation under Section 109.4 of the Customs Act to pay in full the penalty assessment served upon them. If payment in full is not received within 30 days of the penalty, the amount is subject to interest. The interest calculation is pretty low, and I can tell you there are a number of penalties that are not paid within the 30 days. And at some point, there is potentially, if you just took the approach, as someone yesterday that yelled loud and clear to me, he was not under any circumstances paying this penalty. At some point, Customs do have the right to do a collection process, which would probably continue to allow your carrier code to send data, your truck would arrive at the port, and your truck would be held until that payment occurs. When that would occur, whether it'll happen 31 days from the time a penalty is not paid, whether it would happen 9 months after a penalty is not paid, 2 years after a penalty, That's still to be, that was a question that was asked. That was a question that they're waiting for, again, another group within Customs to tell them when that potential collection action could actually happen. You have the right to request what's called a corrective review. If you believe the penalty action taken was incorrect, you may request a review within 90 days from the date in writing or through an online e-filing, and that information is found on this link. We have done several corrective e-filings on behalf of carriers. In some cases where I was able to prove that Customs at the time of processing had in fact made an error and that the penalty was not correctly applied, we were able to receive a cancellation of that penalty. Unfortunately, telling Customs that you had created it, it was sitting there, it had not been submitted, or maybe their system was down, you didn't go back to resubmit, or your driver arrived without the ability, knowing that that ACI was in fact on file, is not under correction. That's not a correction type review. That would be a redress. So you can request a redress, again, within 90 days of the penalty action, requesting consideration as a result. And this is where, again, there's some serious holes in Customs process, because they have taken what traditionally was a redress area that was applicable to the importer or custom brokers or the calculations of duties and taxes, which often was a result of a systematic problem affecting your commercial information system, and you're prepared to invest in corrective measures to remedy the problem, they may consider a redress. Unfortunately, the data that is submitted to Canada Customs in the area of ACI, your CRN number, information about the truck, information about the tractor or the trailer if there's a trailer, information about the driver is not even reviewed or submitted yet, and then cargo data isn't really falling under any kind of systematic type error under that system. So what has been occurring, and some of you know this already by personal experience, whether you went the corrective review route or you went the redress route, unfortunately you received a nice little response that said, thank you for your information, they have reviewed it, and unfortunately it's denied, and the $2,000 penalty stands and you need to pay that penalty. So what have we done? We fielded many calls and listened to your frustration. We have submitted directly on behalf of clients using BorderConnect, or our clients have submitted e-filings themselves, either to the correction or the recourse. And as I mentioned, we have received some positive replies, but the only time we've actually received a cancellation was when I was able to prove that the processing of the officer at the time, or that referral by that officer, there was a problem that was valid, and we got that cancellation. There's been communication with Customs, both locally, regionally, centrally, all the way up the ladder. There has been communication with transportation industry groups. We've had communication with our clients. We're trying to provide insight to clients and drivers. We're providing tips on how to improve your current processes. We've tried to make clarifications to some of the auto messaging that, so it's better understood. Webinars and trainings and emails and outreach, and basically providing a 24/7 support and attempting to stress from day one that this was going to be a new way of doing business with Canada Border Service Agency, and we all had to prepare for that. Considering a number of next steps to continue to address this issue on behalf of our customers, I think this is not a done deal yet. I, for one, am almost taking this on, if you like, as a little bit of a personal crusade. I think this is very punitive. It has left the carrier community very upset. And again, we're all behind all of the technology, behind all of the best practices, behind all of the standard operating processes that we might develop. There's still a human component there, and we're all subject to, at any time, making a mistake that's going to cost, and it costs dearly. So what can you do? You need to ensure all your personnel, and drivers included, understand this new regulation. You need to review your operating practices that may be obsolete or not working. For those of you that had the benefit of a report card, I tried to explain that this was an opportunity to look at your operation and see. Unfortunately, when we, and this has happened several times in the last couple weeks, where we're trying, our 24/7 fax people or tech support people that are taking and fielding phone calls, we're trying, especially when they're talking to a driver, to tell that driver, you need to check, or, you know, it's not, yes, we received the fax, no, we have not completed it yet, it's not on file, you're not ready. And basically, some of the comments that we have heard from drivers is, I'm not waiting anymore, I'm going ahead anyways. You need to stress to that driver that they have to stop. And I know that it's a hardship. I know that you're losing valuable time, and you know, you might be in fact creating a service failure. But at the same time, you need to, again, communicate within the supply chain that there's a time process that has to be acknowledged here. So update your processes. If you're depending on someone else to fax that paperwork, check it was received, check before going off shift to ensure that all manifests are properly submitted. Analyze why the penalty was received and steps to improve it. Use it as a teaching and a learning tool. Yes, it's a costly mistake, but too often I've heard, I'm going to get fired, my boss is going to kill me. All of those statements we know are fact, but we need to use these things as an opportunity to improve and potentially look at what caused it and how do we not do it again. Watch for postings on our front page. Watch for warnings. The users that are inputting the data, the ACI, into the system, we are trying very hard to post warnings if custom systems are down. We're trying to relay as much as possible any problems that we know you might be experiencing. Understand the difference between the U.S. and Canada and ACE and ACI, because even their mitigation process, as I've already mentioned, is very different. I can submit a $200,000 penalty for mitigation, admit there was a human error that occurred, here's what we're going to do to correct it, there was no deliberate intention to make that error, and you could repeat that 100 times, and every single time I'm almost guaranteeing 100% that you're going to get a much lower response to that initially issued penalty. I can't stress this enough. You need to check, and recheck before that truck arrives at the border, because once it's arrived and something isn't in place, whether half of the data was submitted and the other half wasn't, or there was a manifest on file, but there was a shipment that was left off of it. There were 5 cars on the truck and only 4 were attached to that manifest. The second that is discovered, it's going to be an AMPS penalty. Information was not provided in advance of that physical arrival. So take advantage of, in our case, our 24/7 support team. Ask, share your ideas, offer suggestions for improvements. Be patient, and please keep working with us to make any necessary changes that might be needed. I can only tell you that I'm sure this is not, I couldn't be the bearer of great news, that, any of you that have a penalty at $2,000 that, you can look forward to it being canceled. That's probably not going to happen, at least not under the current regulation, the current thinking. But I can tell you that you know, we're doing everything possible. If you have a penalty out there, maybe you didn't notify us, you didn't use us as a resource, which is fine. If you have done that yourself, please bring it back to us. Let it, bring it to me. I would like to include it. For you that are Canadian carriers, I'm seriously considering making a presentation to, because of our location here at Windsor and the border being such a vital component, making a presentation to our local members of parliament and CCing any member of parliament that you bring, you know, from your area into the loop. Somewhere along the line, we need to make customs aware that this is having a huge impact on the carrier community. I've heard it over and over. I'm not going to be able to cross the border. I'm not, you know, I'm going to go out of business. We've heard all of the hardships that this particular type of penalty is offering. Okay, so we're going to turn it over for questions that you might have. I know it's a little more challenging. It's not like we can just sort of talk, but please, if after the webinar you'd like to have some conversation, I'm happy to do that. For those of you that already have penalty and maybe you've been pending a reply from me, I wanted to deliver this webinar, so I sort of gave you the information sort of up front, and I am going to be getting back to each one of you to see how you basically would like us to proceed, but I would like to still do minimally an e-filing on every single penalty, because hopefully it'll get customs attention that, look, there's some concern here, and these are the reasons that this penalty should not be applied, but in reality, I can't change the amount, and in probably most cases, if an error truly occurred, I can't probably get it canceled for you either. Okay, so I'm going to turn it back over to Justin to see if we have any questions. As I mentioned, I invite any of you that would like to have some personal conversation after this webinar to do so with me, and we'll see what we've got for questions and how I might be able to answer those.
Thank you, Debbie. Okay, I'm going to wait about 30 to 60 seconds to see if anybody has any questions you'd like to ask Debbie. So just bear with us as we wait for some questions. All right, I'm going to conclude our question and answer session. It looks like we have no questions. It looks like Debbie probably answered every single question you guys had before going into the webinar, so thank you, Debbie. I'd like to thank everyone for joining us today. Our next webinar will be on Thursday, July 21st at 2 p.m. Eastern, and we will be showing you how BorderConnect's API works. So for those who have colleagues or know software developers that you think should tune in, just let them know. You can also subscribe to BorderConnect's YouTube channel, where you can access the entire library of all our webinars, as well as many software tutorials regarding BorderConnect. So you can access that simply by going to youtube.com and then typing in BorderConnect, all one word. To sign up for a free 30-day ACE or ACI e-manifest software trial, you can visit our website at www.borderconnect.com, or you can email me directly. That's justin@borderconnect.com, Justin, and I will send you a registration link. As always, if you have any questions or concerns, you can contact Debbie directly at 1-800-596-5176, and you can also reach her by email at consulting@borderconnect.com. It looks like we do actually have a question that just popped up here. So Debbie, if you don't mind, I'll read it off to you. Beverly would like to know, I know you've been working on her particular fine accurate EXP dot. Do I need to pay anything now or wait to hear from you before paying?
It would be my suggestion, Beverly, and anyone else that's on the call, if in fact there was an error, there again, isn't probably any sort of opportunity to get that penalty canceled, then you may want to consider payment. At this point, I've been assured by Canada Customs, and I believe there will be some leniency to the payment process. I wouldn't be, running out the door to follow the steps they include in the penalty action for payment. In fact, you might want to wait until I will get back and send an email to each one of you that I am working on your penalty. And basically, as I stated, your options are this. What you do is really a business decision that you're going to make. All I can tell you and warn you that if at some point that payment is not received by Canada Customs and collection action occurs, they will stop a truck or they will issue something that would prevent your carrier code from being allowed to cross the border.
Thank you, Debbie. Hopefully that answers your question, Beverly. We have another one coming in from Peter this time. He asks, if you have a fast shipment with an ACI manifest, do you have, sorry Peter, do you have to include a fast shipment with ACI manifest if you also have a PARS load?
Okay, so Peter, if I'm going to understand the question, you have an ACI that would be required because there was a PARS or a non-fast shipment on that. You can still present CSA in the paper way or the normal way that you do when it's a standalone shipment. Customs do prefer that it would be all electronically sent to them because you have to send that ACI because of the PARS on the load or IITs that might be on the load. It's subject to that report anyways. It does actually make it simpler for the officer. If you're going to present that ACI cover sheet without a shipment attached to it, so that CSA shipment or that fast shipment is identified separately, please make sure that Customs or the driver at the same time he's telling the officer is making them well aware there's a other type of shipment that's not included in the ACI. CSA is exempt from ACI requirement. Unfortunately, this has been one of those areas that's been sort of gone back and forth on, even inconsistencies again between the port and how they handle it. My recommendation, if you're doing an electronic presentation, include all of it, including the CSA portion of it, and then make sure you're in compliance against that ACI that 1 hour prior to arrival. Everything is on file electronically. I think you're just saving yourself a potential for the officer to maybe provide his opinion to your driver rather than what the legislation allows you to do at this point. At this point, it is completely acceptable to do both as two separate functions.
Thank you, Debbie. Hopefully that answers your question, Peter. Looks like Beverly has, she'd like to add to her original question. She's asking, so maybe we may be allowed to make payments, or do you know that?
Unfortunately, the fine print, Beverly, does state that it is payable in full. Obviously, if you were to be making payments, the outstanding amount would be subject to potentially interest calculation. I would say that a partial penalty or a series of partial penalties against that $2,000 is definitely probably going to keep it out of the collection where it's an outright $2,000 debt and no payment required or no payment on file. The legislation right now says it must be paid in full, but I basically said that to somebody recently that you know, he gave me an amount that he could afford to pay on a weekly basis, and I said then that's what I would be doing, is submitting that amount of money until the debt is paid. You know, Canada Customs has to realize that, you know, that's a lot of money to a, you know, anybody, any company size, but specifically, you know, a smaller carrier. They don't have that, you know, luxury of having that amount of money maybe just sitting available for this penalty action. So yes, go ahead and make small payments if that's what you'd like to do, or make a penalty or a payment plan. And you know, currently it says it must be paid in full.
Thank you, Debbie. Thank you for these wonderful questions, everyone. I hope it answers everyone's you know, ideas of what to expect and some things you weren't expecting. So I'm going to go ahead and finish off the webinar. And yeah, if you have any further questions, you can contact Debbie directly at 1-800-596-5176. Thank you again, everyone.